We'll hear argument first this morning, case 22-1025, Gonzalez v. Trevino. Ms. Bidwell.
Mr. Chief Justice, and may it please the Court. Respondents try to overread Nieves in two ways. They need to win on both attempts. Each is wrong and would lead to results this Court could not have intended. First, respondents say Nieves' rule, designed for a representative case of in-the-field law enforcement, now insulates all government officials. Picture the thin-skinned bureaucrat scouring for a crime to pin on his critics. According to respondents, Section 1983 has nothing to say about that. Second, respondents parse Nieves like a statute to say that it limits plaintiffs to a particular type of comparative example. To be sure, Nieves did recognize that evidence of subjective motive alone would not get a plaintiff an inference that this motive caused the adverse action. But Nieves does not blind courts to all but one type of objective evidence of causation. Respondents' position extends Nieves beyond its moorings. If the mayor in this case got in front of TV cameras and announced that he was going to have Ms. Gonzalez arrested because she challenged his authority, the existence of probable cause would make this evidence legally irrelevant. Respondents' position would also toss out of court a critic arrested for jaywalking on a remote country road, even if his town had never arrested anyone for jaywalking before, simply because he couldn't find a non-critic who jaywalked on the same spot. Nieves balanced important First Amendment concerns to protect the on-the-street first responder, making a now-or-never decision to arrest a suspect in his grasp. It did not so loosely dispense with the First Amendment interests as to give government armchair quarterbacks a free hand at the time of their choosing to punish their critics. I welcome this Court's questions.
In Nieves, we dealt with an arrest. And is it different here because you have a warrant process, you have an investigation? Does that break the causal link that we would have in a case just where a police officer arrests the plaintiff?
No, Your Honor, it doesn't. In fact, the fact that warrant exists here helps us for two reasons. Number one, we have an analog at common law, abuse of process, because warrant is a classic legal process. But number two, when it comes to but-for causation, magistrates are required to look at the arrest affidavit in order to issue a warrant. So the arrest affidavit, which we say would not have been issued had it not been for retaliatory animus, is something that magistrates have to take into account, and it is a but-for causation. And as this Court explained in Bostock, and just this term in Murray, there could be many but-for causations. Our burden is to show that had it not been for animus, that arrest would not have occurred. That's just one but-for causation, one but-for cause, and we meet that requirement here.
You say that you used abusive process as the analog. Have we ever used that in these retaliation cases?
You didn't, but that was because there was no process. So in Lozman, you had an on-the-spot arrest. In Reichel, you had an on-the-spot arrest. In Nieves, you had an on-the-spot arrest. So this is the first time that this Court actually sees a case with a warrant coming before it. And just as at common law, a plaintiff could bring a claim, even if there was a warrant. For example, in Jackson versus American Telephone Company, there was a warrant for a serious offense. It was a warrant for assault with a deadly weapon, and it was properly issued, but a plaintiff still had a cause of action because that warrant was used as a pretext for private purposes inconsistent with the exigencies of the writ, in the words of common law.